I think that's what he's commenting too on 13. Defendants have removed timber from plaintiff's real property. Yes, the trees I did cut down in the high water mark, which technically is not his property. I guess that would be the state's property, right? Below the high water mark. And I believe you're able to cut down dead and diseased trees. So that timber was not on his property. It was below the high water mark. The 14 defendants have damaged trees. Again, I think that we're back to, we should probably give the big tree a name. The big tree.
High water mark alert. Lakeshore lines are a legal booby trap often. The state controls up to the ordinary high water mark, and dead diseased isn't a free-for-all. If you guessed wrong on the line, that can be timber trespass damages by the inch. Question: did anyone bring an arborist report or location photos before the cut? That's the receipt the judge will want.
Again, putting a chain, whether or not it's on his property or not, just putting a chain around the tree to get leverage to, I can't remember what we were doing. But this tree, I think the damage that Mr. Burmacombe is talking about to the big tree is this tree abuts the road. So again, back to plaintiff exhibit number 7, you can see the big tree. See how close the tree is to the road? So what has happened over the years, various people, trucks coming out there, it's so close that the tires of the truck end up hitting, I don't know if you know how a tree kind of spreads out when it gets to the ground, but the big truck tires have knocked the bark off kind of the leg of that tree. Me putting a chain around it to use it as leverage on my ATV to winch something, is not going to damage and didn't damage any tree, even if it was on his property, which is not. So I think he's, again, let's gang up on the all-seams with this affidavit. Let's put everything possible that we can possibly say they're doing wrong and put it in this affidavit. But again, that damage was by all the trucks, 26 years. The legs are coming out on the tree. Destroyed or removed no trespassing signs. Okay. So the last couple of years, what the Burmacombes and I think the Millers were doing is, as this started to get going, they wanted to try to declare and say that this property is theirs. So what they did was,
No speculation here.
Oh, it's past the speculation. He already got it out, and now he's going to testify as to actions that were actually
Talk
done
about
and
the actions,
performed.
that's fine.
So, overruled. You can testify.
Translation: the judge is moving us from speculation to first-hand actions. Those flimsy Home Depot no trespassing signs. If they're planted inside a recorded access easement, they don't cancel the easement, but mowing them down is still a bad look. Pro tip: document the obstruction. Don't decimate at photos greater than flattened signs.
So as this conflict started to bubble, they started to put these no trespassing signs that you get at Home Depot. Very skinny and thin, you know, like even smaller than a pencil, the metal, very flimsy. And they would, you know, it's the kind of sign you push in with your feet. It's got 2 legs and then a cross piece that you can buy at Home Depot for $5. They started to go and push all of those signs in. Again, back to the survey, exhibit number 5, they started to put these signs in this access easement without, and this is before they did all these surveys and before they even realized this. I just think that over 30 years, they thought that this is my property because I own the property to the left of it. I think this opening is mine, but it's not. So they started to put all these Home Depot no trespassing signs through this access easement. And again, I'm supposed to use this property to get in and out of my property. So I'm turning a big heavy diesel truck Bobcat trailers, or I'm shoveling snow, again, I have the right to maintain the road and this easement. I'm pushing my ATV with a snowplow. I'm knocking over, a $5 no trespassing sign on the ground in this access easement section. And then same thing on the Miller side, north of lot 3. They were placing those same flimsy Home Depot no trespassing signs on the ground. So just with my regular maintenance, snow plowing, it just simply pushed over, these no trespassing signs that were not on their property anyway, as they tried to establish their claim just by simply putting these no trespassing signs all over in the access easement and on the north side of lot 3. Again, overall, Your Honor, I don't want to have, I don't want anything to do with these guys. I'm trying to have no problems, no conflict. I'm not parking my stuff on, I know that they're getting contentious.
I'm flipping you because we don't have much time. It's
Okay.
3:09. We
Yep,
have
yep.
less than an hour, so let's keep moving down.
Plus 3 minutes.
Plus 3 minutes. You were on 16.
Okay, defendants have removed the stakes showing the property lines as they relate to the survey the plaintiffs completed. I checked into this also, and I called a surveyor. Basically,
Quick Survey 101. The legal monuments are the metal pins. Set corners, not the wooden lathes with pink ribbon. Pull a ribbon, you're tidying. Pull a monument, you're in trouble. The judge will ask, did removing any temporary stake impede access or alter boundary evidence? That distinction decides whether this is maintenance or misconduct.
the markers that are important are the ones that are set by the surveyor in the ground. If I take a wooden stake and put a red ribbon on it, tie it, and pound it in with a hammer, that's not considered a legal monument. If it interferes with the use of the property, you don't leave. What you don't interfere with is what is pounded in the ground. So to be able to access my property or manage or maintain it, I have every right to remove a temporary wooden stake that marks in the ground where the marker is. And that's what I did. I haven't moved any legally placed monuments or pipes or anything of that matter. Because again, when he goes and in the access easement pounds in some wooden stake with a ribbon on it, and it's preventing me from accessing my property, this access easement, I have the right to take down that stake. What's important is I don't remove the monument, what's pounded in the ground. Defendants have vandalized and damaged Mr. Brimacombe's trail cams on his property. We didn't damage his trail cams at all. Nobody pounded a screwdriver on his lens. It's obvious that the camera would have shown that. I think we all know that even if somebody is to come from behind, the camera is going to catch the picture of a hand reaching around either the left or the right side. Certainly if somebody was to come from behind the tree and go like this with a hammer hitting the lens, you'd see that. And they obviously don't have that. So again, he offers no evidence. We haven't done vandalized anything of his, any trail cams, anything of that matter.
Your Honor, I'd object as to speculation. I understand that it's already out, but that's going to happen every single time the way this is working, because there's no question that's eliciting the speculation. So
I understand.
I'm not going to see it. Yeah, so I'm not going to see it until it's out.
Mr. Anderson, I completely understand he is pro se, so he gets to go more in the narrative, and you're going to be able to get to question him.
maybe it just goes to weight. That might be all I'm asking, but
Yes,
there needs
it'll
to be
go to
something.
weight.
Thank you.
I've heard a lot in these 2 days. And I will process it all.
Fair enough.
All right.
Okay, so,
Trail cam, mystery time. One side says vandalized, the other says nope. Claims like this need hard proof approach angles. Timestamps, reflections in the lens, something beyond it must have been them. Also clock the courtroom rhythm. The judge gives a pro se witness narrative room. Then trims speculation. Credibility plus receipts will carry this round.
again, we didn't vandalize damage. You would have seen pictures if that was the case.
That's where the speculations come
Again,
in,
it is
Judge.
speculation. And
Maybe it's for an argument at the end, but.
yes, 18.
Okay. Defendants have graded and damaged the dirt. Your Honor, I'm in construction. I have a Bobcat. I have a bucket. I have managed and maintained that road for 26 years. I have filled in the potholes. I have gone above and beyond. Mr. Burmacombe hasn't paid me $1, but yet he enjoys all the benefits. Saying that a Bobcat is damaging a road is ridiculous. And any construction person knows that you need a Bobcat to, unless you want to go through 2 miles of roadway with a bucket of gravel and start filling in, potholes. That's just absurd. The Bobcat improves the road. It doesn't damage it. And,
Number 19.
I don't know what discarded waste, again, on his real property. We're back to, are we in the access easement? I don't know what waste he's talking about, discarded waste. Again, my philosophy is to steer clear of Mr. Burmacombe and the Millers. I don't want to have any conflict. Certainly don't want to park any of my waste on his property. Maybe he's talking about ash. I don't know. But I haven't discarded any waste. I haven't put any garbage or anything like that on his property.
We have fully talked about number 20, the urination. We can move on to number 21, discarded leaves and snow.
Okay, so just last comment on 20 is that, again, that's not on his property. That's in the access easement.
Again, I said I fully heard all I
Okay.
needed to know on the urination.
Okay. And defendants discarded leaves and snow. Well, what I do is every fall, I use a leaf blower and I blow the leaves off the driveway. So again, back to where Mr. Burmacombe thinks he owns the property and it's not his. Those leaves are being blown onto this open area, the access easement part, and he thinks it's his property. So when I'm using my ATV with the plow on it, I'm plowing that area, I think that's what he thinks is his property, that I'm plowing snow onto his property by pushing the snow up through the access easement.
All right, any final words that you would like me to know, or any final testimony you would like for me to have as it relates to the contempt and or damages? I haven't heard you make any argument or testimony as it relates to the contempt only damages.
Right, and the contempt, again, my understanding of the short-term ordinance, and according to your injunction, is the permission of the county. And again, I have that ordinance right in front of me. It says, any person who maintains, manages, or operates a short-term rental is defined in...
Read it.
Pardon?
Not what you get to do for your testimony.
I'm
Read
telling
it.
you what my understanding was.
Then you can tell me without reading it. So flip
Okay.
it under and tell me what your understanding is.
Well, basically, if you're gonna rent it for 10 nights or less, or the intention thereof, you don't have to go get a permit from the county. It's not enough activity to be considered that. So even though, the bigger legal issues of the injunction itself outside of that, I still kept within the intent. There were only 2 renters during all of 2024. And again, the ordinance says each year. So my understanding is that's a calendar year. So it was my intention not to rent more than, 10 nights for that year until this is all the legal issues are settled.
All right. Mr. Anderson, questions? Oh, actually, I'm gonna go to Miss
Sure.
Osiums. You can ask him questions first if you have questions for him. All right, Mr. Anderson.
Thank you, Your Honor. Mr. Olson, it's my understanding then, based on your testimony under oath, that you admit and agree that you rented the property in 2024. True?
Yes.
Yeah, you also agree and admit that you rented the property in years prior to that. True?
Yes.
Not all years maybe prior to that, because that goes back to the history of time, but I'm talking 2017, 18 and forward to 2023. Fair statement?
Yes, in general, but I don't recall any of the specifics.
Now, it's my understanding, Mr. Elsiums, that in your pleadings, and I understand they've been dismissed, but in your pleadings, you claimed that there was $7,000 a week, which was the market rental rate. Is that a fair statement?
That's including the home and the pontoon boat.
Okay. The pontoon was $295 a day or something like that.
Something like that, but it all depends.
So somewhere between $6,500 and $7,000 for a week.
Can be. Yeah, it depends on the week and the time of the year.
What's your address, sir? Your home address?
The address of the property or where I live?
Address.
1505 Neal Avenue, Court North.
Where?
Lake Elmo, Minnesota.
How long did it take you to get up here today?
Hour and a half.
90 miles, maybe 100 miles, something like that.
Probably 70 miles.
When you rent your property in Wisconsin, you generally don't stay at the property. Is that true?
Correct.
Okay. You're either at home in, would you say Lake Elmo?
Yeah.
Lake Elmo or
Wherever.
somewhere else or on vacation or something?
Mm-hmm.
Yes?
Yes.
For the court recorder, that's all. Okay. And sir, it's my understanding that your property is listed for rent in Wisconsin as of yesterday. Fair statement?
Correct.
Why is that?
Because again, the 10 days or less, I still have, the injunction says permission of the county, and the county says I don't need their permission if it's 10 days or less.
So to rent those 10 days or less in Burnett County, you have not gotten permission from the county. Is that true?
Not explicit permission. I just read the ordinance and it says that you only need a license if you're going to do more than 10 days.
Okay, so you haven't gotten permission from Burnett County then to rent it at any point in time in 2025. Is that true?
No, reading the statute, I had permission because it was 10 days or less.
So you're saying that there's implicit permission from the county?
Well, that's what the ordinance says. I mean, if it...
Injunction versus loophole. He argues the ordinance exempts stays as less than or equal to 10 days, so no permission needed. But injunctions speak plain English. Permission from the county usually means get it in writing. Cross-X zeroes in on the week spot nights versus days math and whether the exemption even applies. Takeaway: if you're under an injunction, don't rely on vibe-based compliance. Paper it or park it.
If the ordinance says...
So let me ask you a question a different way. Have you gone to Burnett County zoning office or anywhere else and asked for permission to rent your property in 2025? It's a yes or no question, sir.
No, it's a qualified answer because, again, I called them up. I'm not quite sure when it was, maybe a few years ago, and asked them about this part of the statute. And they said, if it's 10 days or less, you don't need to bother with us.
Okay, so since this injunction went into effect, have you gone to Burnett County and asked them for permission to rent your property?
No, because I have no intention of renting it for more than 10 days until this is all settled.
Now, sir, my understanding is that your testimony earlier today was that you have not, in 2024, rented your property for more than 10 days. Is that true?
Yes, to my best of my recollection, yes. I know there's been only 2 renters that year, and you presented them to us at the last meeting.
So you rented to Carrie Rottman from July 12th to July 19, 2024. Do you recall that?
I don't recall the exact dates, no.
He testified to that. You wouldn't have any reason to disagree with that, would you?
No. Mm-mm.
And you rented to Christy Haskins from July 1 to July 5 of 2024. Do you recall that?
I do.
You would agree with me that July 1 to July 5 is 5 days, true?
No, it's considered nights.
Okay.
And
so
to get in,
let's talk about the nights then. July 1, 2, 3, 4, right? That's 4 nights?
what I did with Carrie is I gave her,
Is that 4 nights, sir?
no, it's not. What,
July 1 through July 5 is not 4 nights?
I'm talking about legal nights.
I just want you, I'm directing you to answer his question. Then you're gonna get to give me your own explanation when you can do a redirect.
So are there 4 nights between July 1 and July 5, sir?
Yes.
And July 12 through July 19, are there 7 nights for that?
Yes.
And 8 days, true?
No, that would be 7 nights on that.
So I said 7 nights. Now I'm
You
asking
said,
about
you said
days.
8 days.
I did say 8 days. So are there 8 days between July 12 and July 19? From July 12 to July 19, including
Not
July
rental
12
days, no.
Including July 12 and July 19, is that 8 days?
No. Because 8 days means 8 times 24 hours. It doesn't end up that way.
That's your interpretation of that?
No, that's the rental business. I'm in the rental business.
That's your interpretation of that?
Do you rent by the hour?
No, it's by the term. We agree on a general specific amount of time.
So, and July 12 to July 19 is what you agreed to with Carrie Rotman, fair?
Yes, she was allowed to stay there.
She could check in on July 12th,
Yep.
true? And she could check out on July 19th.
Yes.
Same with Christy. She could check in on July 1 and she checked out on July 5, true?
I don't know specifically when she checked out. I told her that I had to stay within the 10-day limit. So I